Thanks, Steve. I appreciate it. Steve and I go way back. Our families have known each other for decades, so it's nice to be here today. Knew his dad, Uncle well. It's nice to be back in the Bremis family. My background is I've been in real estate conveyancing for over 40 years. So I've personally probably done 30,000 closings in my career, representing buyers, sellers, lenders. So there aren't too many issues that I don't know about. And as we go on in our relationship with Bremis, I'll be available to you if you have questions from time to time about a particular matter. I get a lot of questions from realtors as to specific things. I'm always happy to help out with those. Not necessarily, I got a fight with the other agent. They're not paying me. Well, that's another story. But when it comes down to title issues and things of that nature, I'm happy to help out. Steve wanted me to talk today about agency. And agency really is something that it's basically law. And we'll talk about how that relates to what your responsibilities are with respect to the law of agency. But first, we got to define customer versus client. What is the difference between a customer and a client? Well, there is a difference. For instance, if someone comes into my office and they ask me a few questions and they ask me if we're able to represent them and so forth, and what do I think about that particular case, that's a customer. When they finally retain me to be their representative, that's a client. And it's somewhat similar to you. So I have here customer, one who purchases property with the assistance of a broker who is not acting as an agent for the customer, most commonly known as unrepresented buyer, avoids commission disputes. So this is someone who's just helping someone out. Let's say you're helping out your brother or something like that. That's a customer. You might be a facilitator. That's a customer. That's not a client necessarily. A client is one who engages the professional advice and services of another and whose interests are protected by a fiduciary relationship. So that's the big thing here, the fiduciary relationship, and we'll talk about that in a minute. And we call that the principal-agent relationship. And it's one that goes back to Old English law. So this isn't anything new. Much of it isn't even in statutes. It's based on what we call common law, stuff that the courts have decided over many, many decades. Agency. So we define it as the fiduciary relationship that exists when one person, the agent, represents the interest of another, the principal, in dealings with others with their mutual consent and under the principal's control. That's a lot of language. What does it mean? Well, the person, the agent, represents the interest of the principal. So who would be the principal? If you're engaged as a real estate agent, who would be the principal?
The client.
The client. Either the buyer or the seller. They're your principal. And you owe that principal a fiduciary relationship because you have set up an agency relationship. Now, in Rhode Island, they changed this. And much of what's gone on in Rhode Island today isn't agents, they're almost all facilitators because they got out of the agency relationship, that fiduciary obligation. In dealings with others, with mutual consent and under the principal's control. Under the principal's control. So the seller or buyer who you represent gives you your orders. They tell you what they want you to do. Now, sometimes you say, look, that's stupid. I'm not going to put this listing for $2 million. It's not even worth $1 million. If they tell you to do it, you can do two things. You can refuse to take the agency any longer, or you can do what they say. But they're the ones that set the rules. Now, they can't violate law, and we'll talk about that in a couple of minutes. The fundamentals haven't changed for hundreds of years. And the English common law evolved from what was called the master-servant relationship. And this is really an employment relationship to some degree without that fiduciary obligation. So if you're an employee of someone, you act as an agent of the employer. So we all hear the stories of, somebody works for a company and they're employed by the company and they go out and they're doing something on behalf of the company and get in a car accident. And now the person who they hit can not only sue the person that hit them, but can also sue the company that employed them. And that's the master-servant relationship. But what you're doing here is different. That employee doesn't have a fiduciary obligation, so to speak, to the employer. But as a real estate agent, you do have a fiduciary obligation. So, The principal is the party that contracts with the agent. The agent is the one authorized to represent on behalf of the principal. The client is the principal in the real estate brokerage relationship, and the customer is someone not represented at this time. So if someone comes into the office and they say, I'm looking for some properties around here, what's Somerville like? Is it a great community? What do you think properties are, can I get a condo for $1 million? That's a customer, potentially. But it's not a client. Not until they retain you as their agent do they become a client and that fiduciary obligation comes about. Now, the other thing about a fiduciary obligation or a client-agent relationship is consent, informed consent. Consent to a certain act that is given after full and fair disclosure of all facts needed to make a conscious choice. This comes down to what we're going to talk about in a minute when we talk about dual agency, designated agency, buyer agency, seller agency. Okay? Informed consent. My daughter one day was looking for property, right? They're looking for a house. Why would they come to me? I've only been doing this 40 years. Of course, they know everything. So they go to this agent, right? And the agent's showing them this house. They find this new house, but it had been sitting on the market for about 4 months or so. And, we looked at the house finally, and things needed to be done. We said the builder needs to do this. And the agent said, no, they're not doing anything. No, not doing anything at all. Really? Nothing? No, nothing. So I'm like, well, okay, this agent's not being cooperative at all. I said to my daughter, do you have a copy of a form that you filled out or signed with that agent? And she goes, no, we never signed anything. I said, nothing? No, we never signed anything. So no mandatory consent form, no mandatory representation form, right? None. So immediately I called up the agent. I said, can you send me a copy of the mandatory disclosure form that my daughter signed with you? And she said, oh, I don't have one. And I said, okay, that's bad. And I said, have the manager call me. The manager called me. I said, you know what the problem is here? He goes, oh, absolutely. We have a new agent that's going to be on with you, Mike. They're going to send the disclosure form now, and the builder will do anything you want. That's the problem when you don't get informed consent. My daughter thought that the person showing them everything was her broker, but it was not informed consent. She didn't inform them that she was the seller's agent and tell them that, and that she had a fiduciary obligation to the seller and not to them. So informed consent is very, very important. And of course, the fiduciary relationship is one that's spelled out in the slides that I give you, and we've talked a little bit about it, but the big thing about being a real estate agent is that there are responsibilities under Massachusetts law and under general law of principal agency, but also NAR, National Association of Realtors. National Association of Realtors Code of Ethics, 100 years old, starts out with number 1, protect and promote your client's interest while treating all parties honestly. Refrain from exaggeration, misrepresentation, or concealment of pertinent facts. Paint a true picture in your advertising and in other public representations. So start with that. How many here are members of NAR? If you call yourself a realtor, you have to be a member of NAR, right? And you can't be a member of MAR or GBAR or anybody else unless you're a member of NAR. So if you're a member of NAR, automatically you have to abide by these rules. Now, these rules follow the basic fiduciary obligation. Again, protect your client's interest, refrain from exaggeration, misrepresentation, paint a true picture so that you're not getting your client in trouble. Can you get your client in trouble? Yes, of course you can. Remember we talked about the employment situation? Well, if you're an agent and you're out there, and the biggest mistake agents always make is telling people where the property lines are. You ever, more in the suburbs than it is in the city, but if you're out in the suburbs, I hear agents all the time, oh yeah, the property line is the fence back there. How do you know that? You don't know it's the fence. In fact, in most circumstances, it's not the fence. It's not the bushes in the back. It's not the rock wall. And so what happens? You tell them that. They buy the house, find out that, indeed, the property line is 10 feet in, and this was big in the South End where you actually had these little yards, and perhaps here in Somerville and Cambridge as well. And now the owner finds out that they paid $2 million for something, and they're missing 100 square feet. And they sue. And who do they sue? Well, they're going to sue the agent, and they're going to sue the brokerage firm. And they're going to sue the seller because the seller appointed that agent. So yes, you can get your clients in trouble because you owe them a fiduciary obligation and they support you as their agent. So when we talk about fiduciary obligations, they use the acronym OLD CAR.
Excuse me.
Yes.
Can I ask you a question about
Sure.
that? So when somebody asks me that question, I always preface it to say, per the seller.
Right, it's the best way to do it. The seller tells me that that's the property line, but if you're uncertain about that, you know.
Why is it that when they do, you know, if somebody's getting a mortgage, they really don't look at the property lines. They have this, you know, this little mortgage plot plan that tells nothing.
Well, the plot plan is not an accurate instrument survey. What the survey company does is they go to the registry of deeds, they get the plan, everything, whatever's available to the registry of deeds. They go to the assessor's office of the town, get their information, and they go out and they find one bound marker and they take a tape measure and they measure from that bound marker around. So it's not an accurate, a completely accurate survey. You can't build a fence based on it, but it's usually pretty decent. I wouldn't depend on it, again, for building things or anything like that, but it's not bad. But again, it's not going to necessarily show you, from the perspective of where you are on the property, where the lot line is. It's going to show that the house sits there, the house doesn't sit on somebody else's lot line, and that there's no encroachments of driveways and things like that. That's all it's going to show. Many of them don't show if the fences are on the wrong side. They don't show, oftentimes, if driveways are even on the property. So
the best thing to get a surveyor.
a surveyor will do it, but that's $2,500 as opposed to $150. That's right.
The buyer's not gonna wanna do it because.
A lot of times they don't.
It's the responsibility
Right.
of the seller.
Right.
Yeah.
So what is a fiduciary required to provide? Old car. Old car. Okay, obedience, loyalty, disclosure, confidentiality, accountability, reasonable care. Want to give up your license? Because that's a lot. That's a lot of things to do, okay? I mean, I think that's even more than a lawyer has. So, let's break it down. Obedience, the duty to carry out all lawful instructions of the client. That includes not holding open houses or not allowing the entry when the seller is not there, not bringing seller offers below a certain dollar amount if that's what they want, okay? Now, we have a rule that says that you have to bring the seller every offer presented. There's an exception to that rule. Now remember that the seller can give you instructions. And the exception to that rule, and many offices don't even allow this exception, but some do. If the seller says, don't insult me, don't bring me any offers under $900,000, and you get an offer for $850, do you have to present that? Well, not under the law, no, but your office may have a different policy on that. But if the seller gives you an instruction, you can abide by that instruction. Other than that, given no such instruction, you have to present every offer to the seller. I've seen many instances in which agents don't do this. They'll tell me, that's insulting, I'm not bringing it to them. You don't have a choice. And again, the seller on that particular day may be happy to take that offer. We don't know. Things change day to day in sales transactions. Again, things that do not include the seller instructing you not to reveal a particular defect in the property. Here we run into a real situation. So you know that the regulations regarding realtors say that if it's a major defect in the property, that you have an affirmative obligation to inform the buyer. Okay? If it's a major defect in the property that you know about and that you're sure about, you have an obligation to inform the buyer of that. Now, you see water stains on the basement floor. Does that mean that the property has a water problem? Not necessarily. You could have had a burst pipe that caused water to flow and that created it. So don't ever assume, but I mean, if you see a whole part of the roof is falling off, if you know there's mold in there, technically, under the regulations, you have an obligation to inform the buyer of that. Now, a seller could tell you, I don't want you telling the buyer that. Now what do you do? Well, you have two choices. You can violate the law, or you could tell the seller, I'm sorry, but I can't do that, and if you want me to do that, I have to give up the listing. Very tough, two very tough choices, but you have to make one of them. Okay? On loyalty, the utmost fidelity and care to act in the best interest of the client. So failure in any way to breach a fiduciary obligation violates the requirement of loyalty. Undisclosed dual agency is an example of a violation of fiduciary duty. So this is one of the big ones, loyalty. You must be loyal to your client. Now, until 20 years ago, every agent was a seller's agent. Everybody was the seller's agent. And then we had buyer's agency come up, which, by the way, started out really rocky. Like most realtors hated buyer agency, they fought it, they castigated the buyer's agents. Today, obviously, that's not the case. But when we had all agents being sellers' agents, then it wasn't too much of an issue. You were going to be loyal to the seller. Now, what happens if you say to the buyers, look, seller's in a divorce. I know if you come up with 500 grand on this deal that they'll take it. That's violating your duty of loyalty. That is now making you a violation of that one principle. You violated that one principle. So you got to be very careful with that. Disclosure. The duty to disclose all information relevant to the client. You must keep your client apprised of all information that's in their best interest. What you know, they should know. If the agent of the seller, you're communicating all offers to the seller. Again, if you're a buyer's agent, you're communicating all pertinent financial and condition information you have available. So let's talk about buyer's agency for a minute. Let's say that you're doing a property and you see it's a finished basement on a renovation. Do you now go down to the building department and find out if that was done with a permit? I don't have an answer to that. I really don't. And this is the conundrum we have, especially in the suburbs, where it's more common, where you'll see a room over the garage. And, this is an older house and the room looks brand new. And now, the question is, do you go to find out? Your buyer's agent, do you go to find out? In that instance, I would probably do that because, again, that could be a real issue. Remember that if you do something in the house that required a building permit and you did not get the building permit, and it is later found out that that's the case, the building inspector can have you rip out the entire area that was rebuilt. And then if you want to rebuild it, you now have to rebuild it in accordance with today's code, not the code back when it was built 7 or 8 years ago. So this is a real conundrum for buyer's agents. Disclosure. Do you have the obligation to go find these things out? Well, many times we'll tell people, look, if you have a concern about this, go to the building department and ask them. I don't necessarily want to take on that responsibility as representing a buyer because that's not what we do. We're not out there to vet the property. That's your job or that's the buyer's job. So do you need to vet the property, and how much do you need to vet the property on behalf of the buyer? It's a good question. And how far you want to go, and depending on what the property is. So again, you have a certain obligation to disclose what you do know. Do you have to find out everything? Not necessarily. It depends on how you want to be as a buyer's agent. Affirmative disclosures of defects, as I said, Massachusetts Chapter 93A, certain regulation in accordance with that. Any person or legal entity subject to this act fails to disclose to a buyer or prospective buyer any fact, the disclosure of which may have influenced the buyer or prospective buyer not to enter into transaction. That's a violation of Chapter 93A. That's triple damages. That's attorney's fees. So again, failure to disclose to a prospective buyer, the disclosure of which may have influenced the buyer or prospective buyer not to enter into transaction. So it's got to be something significant. It's not that the dishwasher isn't working, all right? It would be, significant evidence that there's water in the basement, significant evidence that the roof is falling in, something major, that there's mold in the house, that the HVAC system doesn't work, things of that nature. You can't just, go in there if you know about these things. So, a lot of times, you'll have a buyer go do an inspection, right? And you're the listing agent, and they do an inspection. They find out there's a significant defect. They walk away from the deal. Now, under Chapter 93A and the regulations associated with it, you have an obligation to tell any new prospective buyer about that defect. But it's a question as to whether it's a major defect. Is it something that the buyer actually would walk away from the deal if they found out about?
Can I ask you a question about
Yeah.
defects? So if you're a seller's agent, is it acceptable to say, if there's anything you don't want me to disclose, please don't tell me?
I don't know.
I don't know if that's on the line.
The problem is, I was also a trial attorney for a long time, so all I need to do is have the seller say, well, I told her, she asked me if there was nothing to tell, so I didn't tell her about it, but maybe I should have. You don't want to get into that. I would just say, don't get into it if you don't need to, but again, it's a can of worms. Do you want to open the can now, Or do you want to open it 3 days before the closing? It really depends. And it depends on what the defect is. The biggest one, again, is building things without a permit. That's the one that is causing people to stop. And that's because, again, they may have to rip that out. But more importantly, an insurance company can deny coverage. Let's say there was a fire or significant damage to the property. And the insurance company finds out that the second floor bedroom or the third floor bedroom was built without a permit. They could deny coverage on the entire claim because you lied on the application, which basically is always going to say that everything was built in accordance with zoning and principle and permits. So you don't want to get into that. Insurance companies love to deny claims. They'll use anything to deny claims, and we don't want to get into that. Also on rental, it's almost same subsection. It shall be an unfair, deceptive act or practice for an owner to rent a dwelling unit which at the inception of the tenancy contains a condition which amounts to a violation of law which may endanger or materially impair the health, safety, or well-being of the occupant. That's on the seller. Most importantly, it's lead paint or any serious health violation like a mold and things of that. So sellers have that obligation in rentals. Now, one of the big things comes up. You're a rental agent, and you know that there's lead paint on there. And you have a nice couple, and they have a 2-year-old and a 3-year-old. And you say, no, I don't want to show you this property. It's got lead paint. You can't do that. That is discrimination, and you'll go up before MCAD. You can't do that. Now, it's nice for you to say that, because you're trying to protect them, but you can't do that, okay? So people with children can't be steered away from a property because there's lead paint. That's a violation. No different than if you said to somebody, an African American, oh, this guy's a racist, I don't want you to rent in here, he's going to be terrible to you. You can't do that either. You can't move people away from a listing because there's something there that you feel could hurt them. You have to tell them, and they have to make that decision themselves.
You don't know there's lead paint, though, until it's tested, correct?
Absolutely. So never, ever say that a property has been de-leaded, either in a purchase or a rental, unless you have a de-leading certificate from a licensed person that has then given it to the Board of Health for approval. If you do that, if you say it's de-leaded, you have no idea. And you could be in big trouble. And the Pierce versus Wheeler case is a classic example of that. So it says buildings built prior or after 1975, not an issue. It could be. I love this when people say, oh, it's a new construction, there's no lead in it. Did they get anything from China? Because China's got plenty of stuff in it that has lead in it. Lots of wood products and things that have lead in it. We don't know that there's no lead in that property, so never say it. Never say it. If there's a de-leading certificate, give them the de-leading certificate. Well, we have a de-leading certificate that was issued. I'll give you that. Well, is there lead in it? Look, I don't make that decision. This is a de-leading certificate. If there's no de-leading certificate, assume there's lead. Okay? If it's over after 1975, you don't know. You have no idea. Have them sign the form, and the seller says, I have no idea. Honestly, I wouldn't have a seller sign that says there's no lead in there unless they really have tested the whole property.
How about landlords not choosing their people with the kids?
That's their problem.
So you're not involved in that?
No. If they do that, that's their problem. If they want to discriminate for any reason, that's their problem. Just don't be a party to it. That's all. And what about off-site conditions? What about, there was a landfill, right? You're selling, say, in Arlington or something like that. There was a landfill there. Do you have to tell them about that? If it's a significant issue, if the seller and the buyer, if known to the buyer, might walk away from the deal, yeah, probably. So we have a lot of parks and stuff that were landfills at one time, or we have places that had, significant hazardous waste. You have a basement on a property, and this is pretty real in this area. You got a basement, and there was an oil spill in the basement, okay? And they covered it up. That's a pretty serious defect. A lot of people would freak out if they knew there was an oil spill on that property and never got to dispose of it properly. Let's say there was an oil spill. The oil company put it in the wrong tube. It came out into the basement, or the oil tank in the basement leaked. But a certified company came out and took care of everything and so forth. I would still mention it, but show them that it had been taken care of. Again, people freak out over hazardous waste. I wouldn't fool around with it. I would disclose it, but tell them it got fixed. Even if there was water in the basement at one time, they then put in a drainage system and they put in a sump pump. Tell them, yeah, here it was, but it doesn't exist anymore because they put all of this in here. Was there radon? Yeah, there was radon, but there's a mitigation system, so the radon isn't an issue anymore. You know, those are the types of things to be careful of. So again, how do you handle the disclosure? Well, again, if the seller tells you, I don't want you disclosing that to anyone, then, you know, that's a problem for you. Should you tell the seller you're going to tell them? I would. I would always tell the seller, look, there's a defect here. I know it. I have to, under Massachusetts law, I have to tell the buyer about this. You know, tell them that. And say to them, look, this isn't going to be hidden, all right? This is going to be something that's going to come out. So let's get it over with now. All right, don't try to hide it. It's not going to help you to hide it. You could be sued later on this because you're making representations in the purchase and sale agreement that you don't know about it, but in fact you did know about it. So I, as a litigator, I could sue and win that case. Yeah.
When advertising a listing that maybe you do know has an issue, is there any language you can include, like, for instance, sold as is, or buyer to do their own due diligence, seller makes no representations?
Every deal says that pretty much. It doesn't help you.
Okay.
If there's a defect significant enough that the buyer may walk away from the deal had they known about it, that language doesn't help at all. It's still a Chapter 93A violation.
You know.
And again, 93A violations are triple damages and attorney's fees, hundreds of thousands of dollars. You know, I had a realty firm, one of the best realty firms in Boston, the ones that does the $30 million deals, right? And the owner calls me up one day. She goes, Mike, I want you to come in. I want you to talk to my agents about holding security deposits in Massachusetts. I said, what? That's your office? I mean, you don't rent. You sell condos at One Dalton. She goes, yeah, the problem is that we're selling these to like Arab sheiks who are buying them, and then they want us to rent them for them. So the rentals are $30,000 a month. And if I said, I get it. You take the deposit inappropriately. Now you owe triple damages, $90,000. Yes, I'll come in and teach the class. And it made sense. Same thing with you. You know, if you ever want one of those, we can talk about that.
I don't understand what they were looking at. I don't understand.
So they're renting the properties on behalf of their clients.
Yeah.
They are holding a security deposit. If you hold it the wrong way, you can be sued for triple damages.
Oh, you talk about not putting it into an interest-bearing.
Right, doing it exactly as you're supposed to be doing it. Yep. Confidentiality. Non-disclosure of pertinent financial information to others, such as financial difficulties of the seller, other offers. Duty survives the termination of the relationship. So if the relationship ends, you still have that obligation. Duty does not apply to legally required disclosures, such as known material defects of property. Again, you have to disclose those. So if they tell you something, look, I'm getting divorced, I need to sell this quickly, can you help me out on this? That you can't disclose that information. If the seller says, I'm willing to take this amount of money, but see what you can get, don't disclose that information. That's between you and your principal. That's part of the confidentiality requirement. Accountability, obviously, you can't commingle funds. You have to keep them separate. You have to do all of the things that I'm sure your office does in terms of holding the funds of the client. The biggest thing today is wire fraud and bank fraud. So, for instance, if you're getting a wire in for a deposit, you have to take all of the circumstances into consideration and be extremely careful. There are realtors who are losing security deposits to fraudsters. And those security deposits are pretty sizable sums of money on a lot of these transactions. So I'm sure your office has protections on that, but be very careful yourself. If you get a check from somebody for a security deposit, bring it here immediately, get it deposited immediately. Don't go to Starbucks, leave your folder out, because somebody smart opens the folder, takes a picture of the check, and goes down and commits fraud on it. Okay? You have to be extremely careful with all of that stuff. So be careful with all of the information that you have as well about the property. Be careful to protect that always. If you have laptops and you're walking around with your laptops, they better have really good security in them. You better have locked them out with a heavy passcode, because you're going to Starbucks. I don't like Starbucks. I don't like Starbucks to begin with, because I go into Starbucks and I don't understand it. I go up there and, they had like the blonde coffee. So I ordered a tall blonde. And I giggled, and the lady just looks at me, and I go, well, it's kind of funny, it's all blonde. She goes, we were told not to laugh at that. But then I go there and I get a cup of coffee and I say, yeah, I'll like a cup of coffee, with a tall blonde with some milk, please, or cream in it. And the guy goes, yeah, the cream's over there. I go, what? The guy goes, the cream's over there. I go, dude, the lady in front of me just came in, ordered a coffee with like 90 things in it. You don't have a problem doing that, but me, you can't put the cream in it? He goes, yeah, cream's over there. I go, yeah, your tip's over there too. Don't walk across the street when the cars are coming. You go to Starbucks. You leave your laptop there. You go up to get a cup of coffee. It can be stolen in a minute, right? Sitting in your car. You forgot to lock the door. Stolen in a minute. A simple passcode that you have on there can be broken in a heartbeat. And you have a lot of data on your laptop, a lot of personal information on your laptop. That's on you. That's on you personally and the firm. So both of you could be sued on that. You don't want that kind of problem. Reasonable care and due diligence. The duty to act competently and being capable of performing the duties. Reasonable care in ensuring information being transferred either to the client or on behalf of the client is accurate. Not providing information agent or broker is not sure of without informing the party otherwise. Don't simply surmise something is the case. Find out exactly what the case really is. One of the things, too, is, I get a lot of this lately, and I'm a little surprised, and I deal with hundreds of brokers. I'll say to a broker, yeah, we're coming up on mortgage contingency date. We're not going to make it. Would you like to send out something to get an extension of mortgage contingency date? Or, hey, we're not going to get the P&S signed on time. Would you like to send out an extension to sign the P&S? Oh, I don't do that. I let the attorneys do that. Really? That's not your job anymore? I mean, come on. Are you calendaring mortgage contingency dates on behalf of your clients, your buyers? Well, you should be. Are you doing them on behalf of your sellers? You should be. Are you depending on the attorney? This is your job. This may be the attorney's job too, but this is ultimately your job. You're getting paid a pretty significant sum, and you're an agent of the principal. You owe that principal reasonable duty and care. So calendar those dates in there. If a mortgage contingency date is coming up, talk to your buyer and say, listen, did you get the mortgage yet? I do. I calendar every one of them. I calendar them 2 days before, 1 day before, and day of. There's no way I'm letting one of my buyers go beyond the mortgage contingency date unless I know that they've got a commitment from the lender. And it should be exactly the same for you. And on behalf of the seller, let's find out, what is that date? And then after that, you could tell the seller, well, we haven't received anything from the buyer, so it looks like they're ready to go with their mortgage. Okay? You can't necessarily talk to the mortgage lender and find out what's the situation. They're not technically supposed to give you that information. But if they've gone past that date, now let's say they've gone past that date, and you find out that they didn't get the mortgage. Can you put the property back on the market?
You owe them money.
No? Why not? No, you can't. You're right. You can't. And that's because the date, place, and time for performance is the date, place, and time and location that you've put in the purchase and sale agreement. It's why we don't do TBD, right? I thought TBD was like a disease. What did you do? What did you put in there? TBD. To be determined? No. I have to be able to go to court and say to a judge, Judge, the seller didn't show up at the closing. They're in default. How do you know, Mr. Krone? Because we were at the Middlesex Registry of Deeds at 12 o'clock on March 17th. And we were there, and they weren't there. They've defaulted, okay? If I don't have that exact information in the P&S, I can't prove the default. So here again, you've got to be very careful to make sure that your clients know what's going on. Now, if they do go past the mortgage contingency date and you find out they didn't get a mortgage, they still have the right to purchase the property up until the date they default. So it could go all the way to the time of closing. Now, they might have gone to another bank. They might have an uncle that's got a lot of money. Who knows? They may default in the end. But you cannot. And even if they called you and said, we're going to default, that's called anticipatory repudiation. And I talk about this when we talk about purchase and sales and closings. That doesn't mean anything. Do not go by that. Until they sign a document saying that they want to rescind the contract and they're going to assume the responsibility of the deposit being lost, you don't know that that deal is dead. And don't assume that that deal is dead. Because I've seen situations where they try to fake you out and then they show up at the closing and you're not there and they say, oh, seller wasn't there, they're in default, we want our deposit back. So don't play that game with them.
Could I ask you a question about
Yep.
emails, okay?
Yep.
So I often see, it used to be that we signed an extension to purchase and sale, extension to mortgage commitment, and it was a separate document. I see a lot of times now that agents or even the attorneys are extending between themselves via email. Is that binding?
Yeah, so a lot of times we'll put a clause in the purchase and sale agreement that says that that is binding and that the attorneys themselves can do it between themselves.
Okay.
I don't think any court's going to have a real problem with two attorneys that have that clause in the P&S saying, we're going to extend the mortgage contingency date or we're going to extend the closing date. I don't worry about that. Would I like to get, prior to that, if there's going to be an extension of the time to enter into the P&S, I'd like to see that in writing signed by both of the parties. Because we don't have at that point any authority of the attorneys to bind their clients. So if it's anything up to the time that we sign the P&S, and if there's a clause in the P&S that says they're okay to do that, that's fine. But up to that time, I would want to see an actual written document that says that can be docu-signed or whatever, that says we're extending the time to sign the P&S. In this market, it's really tough because it's a seller's market. And, you know, if you go past that date and the seller wants to put it back on the market, they could, and they will, because that market might have risen in that period of time to more money. When does the relationship end? When they either terminate it, or the agreement expires, or the transaction's completed. So that's when your relationship ends. What happens to the confidential information? It survives the termination of the agency relationship. And again, if you bring another client to that property at a later time, you have to keep that information private. What type of brokerage relationships do we have? Well, traditional agency was always seller brokerage. Dual agency. Let's talk about dual agency for a minute. Dual agency scares me. It scares me because there is no way you can be a fiduciary of two people in the same transaction that have opposing views. You will violate your fiduciary obligation at one point or another. How are you possibly going to keep the information that the buyer has given you and the seller has given you separate in your mind so that it doesn't meld? Well, of course it's going to. You're going to know what the buyer's tolerances are and the seller's tolerances are. So that's not fair to either one of them. You know, can you give that loyalty to one and the other at the same time? I don't know how you can do that either. You know, so confidentiality, disclosure, loyalty. I mean, reasonable care, of course you can. So dual agency presents a lot of conundrums, and I have it, you know, in more detail in the slides. But the biggest thing, if you're going to go to dual agency, there has to be a full informed consent of both of the parties. You have to tell both of the parties that you're going to be representing them and that you're going to be handling the transaction. Now, if you're simply the seller's agent, as Steve had brought up before, if you're the seller's agent, you can certainly assist the buyer with certain things. You know, it's like I can represent the buyer and the lender, but I can also prepare the deed and any other transactional document that the seller may want at the transaction if they don't have an attorney. I'm not representing him. I'm not his client. He's not my client. I'm simply facilitating his aspect of the closing. So if you run into a situation where you've got the listing and you've got the buyer coming in, do you have to have the buyer put you on as a buyer's agent? No, not at all. You can handle the transaction. You're going to give them the mandatory disclosure that says you represent the seller and explain to them, look, I am handling the transaction. If there are questions that you have, I will try to answer them. But I represent the seller, but this should be fine. Everything should go smoothly. And if there's a problem, we can certainly talk about that. And I can have you work with one of the agents in our office. And you could go to a designated agency. So that's the other option. But in order for you to be able to do a dual agency, Massachusetts consent to dual agency form is issued by MAR. You have to use something like this, okay? I've got it, a little picture of it in there. If you Google it, you'll find it online. You have to have them sign this, okay? The buyer and the seller should both be signing this consent to dual agency. Again, I don't like it. There are even some offices that ban it. And again, it's something that, you know, you want to make sure that it's expressly authorized by the parties, you know, that it's intended to be beneficial to both of them. But it's not necessarily something that I particularly recommend to anybody. Designated agency, on the other hand, is a way to handle a situation in which you have the listing and the buyer comes to you, okay? now you feel uncomfortable representing the seller and the buyer, you could then designate someone within the firm to act as the representative of the buyer. And you can work out a deal with that person. Say, hey, listen, I'm going to do 90% of the work. You're going to do 10% of the work. I'll give you X percentage of the fee on this. Or you give them split depending on how much work is going to be done on both parties. What happens when you have an open house? You have an open house, you have the listing, right? Buyer comes in and really wants to move on this. You're out of town. One of your staff or one of your colleagues here is handling the open house for you. What happens? They take it. Do they have to give a mandatory disclosure that they are now representing them as a buyer? Do they have to become designated agent? Good question. No simple answer. I have people that put in there the mandatory disclosure at the open house, saying who the listing agent is and who they represent, and then have forms like that if they have a person there representing them that they want to be the designated agent. They can have that form and have them fill it out right there too. Or they could be buyer's agent. Yes.
Do you recommend having something posted if someone's doing an open house for the listing agent and they're not the listing agent?
I like to see it because that's being honest to the parties and it's disclosing to them. And it's telling them that the person that they're talking to there is the seller's agent or the associate of the seller's agent. So I think it's important, especially if people are going to start getting into real conversations with you and they're getting ready to make an offer, which today in the seller's market happens. You know, they're desperate. They're going to sign the offer right there. You know, I think you have to have that disclosure. The interesting one comes up with you have someone call up and say, I want to buy that house. Haven't seen it, no idea, I want to buy the house. You better send them the disclosure form before you do anything. Send it to them and make sure they've got it, okay?
You know, a lot of us do open houses for Steve. Steve's the listing agent.
Yeah, Steve's got issues on that, I know.
No, yeah, no, but, so what ends up happening is, you know, I would think at that point that I could proceed to be a buyer's agent for the person
You could.
who comes in.
Sure, of course,
Even though,
yeah.
you know, I can actually put the disclosure on the table that, you know, I'm working, I'm associate of the seller.
It depends on what your arrangement is with Steve.
Yeah.
It depends on what, if Steve is asking you just to cover it for him,
Yeah.
you know, then he doesn't necessarily want you to take half the commission. But that's something you have to work out with the office, you know, and I would say that that's the way you should do that.
Yeah.
There's also a Massachusetts consent to designated agency that's in there. Again, that designated agent really has to have a firewall between the listing agent and themselves. They can't really start conversing about the transaction because that would violate their agency obligation. So the designated agent, the only reason we call them a designated agent, it's someone within the same firm that party has designated to represent the buyers. But that person still owes that buyer all of the duties of fiduciary obligation. Again, when do you get these forms filled out? At the very beginning. We talk about the mandatory disclosure. Mandatory disclosure has one relevant term in it. Mandatory. You have to give it to people. When do you have to give it to them? When they walk in the door? Excuse me, here's a mandatory disclosure. No. If they've come in and they're looking at a listing, they want you to bring them somewhere, they want to discuss specific properties with you, and that's a listing that you have, or you want to be the buyer's agent, fill out the mandatory disclosure form. Let's say you're looking at a property that you have. You give them a mandatory disclosure. You are the seller's agent. They go to the property. They don't like it. Can you show us more properties? I can. I'm now going to rip this one up, and I'm going to issue a new one that says, I am now your agent. Okay? And what I would do is have them, you know, initial that this is no longer valid as a seller's agent. You're now the buyer's agent. This happens. It happens frequently. Facilitator. Rhode Island went to facilitation in a lot of ways. Rhode Island now has whole laws relating to realtor facilitators. And the big element there is that that person is no longer a fiduciary. They're not an agent. Agency principal law doesn't apply to a facilitator. They work to complete the transaction. They don't have fiduciary responsibilities. Their duties consist of accounting and any other facilitator duties promised to be undertaking. No duty to keep information received from seller or buyer confidential. You're not a fiduciary. present each property honestly, accurately, no license required, but can step into late agency. That isn't necessarily true in some instances, so I think you're better to have a licensed agent in Massachusetts be a fiduciary than somebody that's unlicensed. I've talked to people at MAR and so forth, and there's some real questions about that. And you have an agreement with the parties. So you could be a facilitator, have both parties sign a facilitation agreement and do it, and get paid a fee. Now, generally speaking, these are not going to be the same type of fees that you're going to get if you're an agent and you have a fiduciary obligation and you're really working on behalf of one party or the other, which is why facilitators are really in a vacuum right now in Massachusetts. We don't really have any rules or laws pertaining to them like Rhode Island does and other states do. So you can be a facilitator, make sure you explain to everybody what you're going to do, tell them what you're going to do, and tell them what the fee is going to be up front, just like you would a listing agreement. Steve, do you guys have facilitator listing agreements or anything like that?
Other than their standard disclosure now.
Okay. So, that would be the one thing that maybe we talk about someday is having a facilitator agreement so that the parties know exactly what's going to be happening in that relationship. That's basically it on these slides. Does anybody have any questions? Just be really mindful. When you're the agent of the buyer or the seller, you owe them that fiduciary obligation. You have to abide by those fiduciary rules. If you don't, not only can you lose your license in Massachusetts, like that woman who didn't give them the mandatory disclosure form to my daughter. She could have lost her license for doing something like that. People that are keeping the deposits improperly. You could lose your license for these types of things. And that means you're not going to get a license anywhere else. So be very mindful of that. Also, Steve's built a business here over many decades. And you don't want the business to suffer because you've made a mistake or violated a fiduciary obligation. So if there's ever any questions about this or any concerns about this stuff, I'm always available to answer those questions. I've got sheets over there about Flynn Law. In Flynn Law, we're attorneys. We do the attorney work. We've got a great staff of attorneys and paralegals. All we do is real estate. That's all. We don't chase ambulances or take people to court. You're never going to hear from us, "Oh, I'm sorry, I can't do that tomorrow. I'm going away," or "I'm sorry, I'm in court for 3 days." No, you're not going to hear that. We have people that cover all of our situations all of the time, and we're always available to answer questions. Our fees are really reasonable, and our service is pretty good.
Do you work from cell phones or?
Cell phones, you have my cell phone number in there. I don't have an office phone. I have a cell phone, and I have my email, and I look at it all the time. I'm crazy. I'm on the beach at Crete, and I'm still looking at my emails all the time, as long as I can get an internet connection, because that's this business. It's a business of minutes oftentimes, and especially when we represent lenders too. Don't think you're the only ones that put pressure on us to get stuff done. Believe me, the lenders do the same thing to us on a regular basis. So we're attuned to that. Yeah, we know about it. We're in tune to it. So we're happy to manage it in that way.
So what if the buyer waives all the inspections and stuff? Are you still liable for can you still get sued for the problem?
It's a very good question, and I'll say this about waiving inspections and mortgage contingencies. Be extremely careful and inform your client. What I do when I have a client who's waived inspections and mortgage contingency, first-time buyer especially, is I will tell them, look, I'm not going to tell you should I do that? Well, first of all, you've already signed it in the office, so it's a little late. But what I will tell them is this, look, you've waived the mortgage contingency. If you were not able to get the mortgage, do you have the wherewithal to purchase the property? No. Okay, if you don't get the mortgage, can you sustain the loss of your deposit? No. That'd be catastrophic. Okay, so these are two possibilities. But I have a mortgage, I have a pre-approval. Pre-approvals, depending on who they get them from, could be great or worthless. So I don't ever depend on a pre-approval. And plus, every lender qualifies two things. They qualify the borrower and they qualify the property. The pre-approval has not qualified the property because we don't have an appraisal yet. So what I tell them are the consequences of their actions. You want to waive the inspection. Do you know anything about real estate? No, this is our first property. Okay. If the heating system went, can you sustain a $10,000 or $15,000 cost to repair it? No way. We don't have that kind of money. We're almost broke right now. Okay. Well, that is a possibility. I mean, we don't have an inspection. We don't know what the property looks like. We don't have anything about it, so, you don't know what the defects are. And if you have to repair the defects, they're going to come out of your pocket. It's not going to come out of the seller's. And if they still want to go forward, fine. If they say, you know what, I don't know. I don't know. This is what I would do if I'm you, okay? You don't have to tell them, and I never tell people what to do, ever. Never tell people what to do. Like on your instance, you could say, look, if you don't waive it, pretty sure seller's not going to take your offer. We could put it in. I'm happy to put it in, but I'm pretty sure they're not going to take your offer. Now, what are the consequences of you waiving it? Well, these are possibilities, not probabilities, but possibilities, okay? I see you've got a pre-approval, from this company. They're pretty good about that, but we haven't qualified the property yet, so you may not get the full amount of the mortgage. You may have to put in more cash. If you waive the inspections, we don't know what the property looks like. I don't have any evidence of what the property looks like. I don't know if there are any defects. If there are defects, you own them, not the seller. And if they say, we're fine, we still want to go forward with it, then fine, go forward with it. You can't be sued when you do that.
Yeah, but Mike, you don't have to waive the commitment, mortgage commitment and the appraised value. So you can also go in and say,
Subject to appraisal.
yeah, subject to.
Yeah, but nobody
appraisal,
signed, but
or
we don't see that. We don't see sellers allowing that anymore.
Or subject to the appraised value coming within $10,000.
Yeah, you can do something like that. Yeah, but again, it depends what's in the offer. That's you.
Yeah,
That's you putting it in the offer, not me.
yeah,
Because I can't put that in the purchase and sale agreement if it's not in the offer. The purchase and sale agreement has to be the mirror of the offer. So whatever's in the offer will go in the purchase and sale agreement. What isn't in the offer, I can't put in the purchase and sale agreement in the seller's market. They just won't take it. They've waived 13 other buyers. They're now all of a sudden going to give up something that they didn't have to give up with some of the other buyers. Well, I don't want to take any more of your time. I know you got to move moving on your thing.
much.
All right, my pleasure. Thank you, everyone. I appreciate it.
Need to see Michael again.
So I've got a few bottles there, a couple of some of our pieces.